We begin with a landmark ruling in the United States where the Supreme Court has granted former President Donald Trump some degree of immunity. They say former presidents cannot be prosecuted for any actions that were within their constitutional powers, but can for private acts. The justices overturned a lower court's decision that had rejected Trump's claim of immunity from federal criminal charges. Earlier this year, the court was asked to decide whether Trump was in fact immune from prosecution for his role in the January 6, 2021 riot at the U.S. Capitol when he was still president. The timing of this ruling is important because the window for a trial to happen before the November election is narrowing. Now, the former president is currently facing 3 criminal charges. Let me walk you through them. The first, as I mentioned, is for his role in the January 6 Capitol riots. Prosecutors claim Donald Trump sought to exploit the protests to delay the certification of President Biden's victory. Now, Trump's second case concerns the classified White House documents found in his Florida home, Mar-a-Lago. And finally, the former president and 18 others face criminal charges in Georgia, where he's accused of conspiring to overturn his narrow defeat in the state. Now, one justice who objected to the ruling was Sonia Sotomayor. She has decried it as a mockery, saying the court's ruling effectively means presidents are above the law. In a statement outlining her objections, she wrote, "The relationship between the president and the people he serves has shifted irrevocably. In every use of official power, the president is now a king above the law," she says. "With fear for our democracy, I dissent." U.S. President Joe Biden, too, slammed the Supreme Court decision, warning of what it could mean for the future.
Today's Supreme Court decision on presidential immunity, that fundamentally changed. For all practical purposes, today's decision almost certainly means that there are virtually no limits on what a president can do. This is a fundamentally new principle, and it's a dangerous precedent, because the power of the office will no longer be constrained by the law, even including the Supreme Court of the United States. The only limits will be self-imposed by the president alone.
Barry McDonald is a professor of law at the Pepperdine Caruso School of Law in California. Welcome to DW. Now, Professor, before we get into the details of the ruling, your reaction to the court's decision?
Well, a little bit of disappointment, because I think the ruling was unnecessarily broad. The court went into sort of areas of immunity for the president that it just didn't need to do. It created sort of 3 categories. One was core constitutional responsibilities for which the president is absolutely immune from being prosecuted for criminal acts that he took while in office. The second is sort of qualified immunity or presumptive immunity for actions that don't fall in that core area where the president actually shares power with Congress. But even there, the president, again, is sort of presumptively immune from being prosecuted. So the only area that is clear where the president enjoys no immunity is for unofficial or private criminal acts conducted while in office.
A lot of people are asking where that line between official acts and private acts can be drawn. How can an objective distinction be made here?
It's very difficult, and even the majority opinion written by Chief Justice Roberts acknowledged that it can be a very fuzzy line. So the court essentially said any action taken by the president that is arguably within the president's constitutional or statutory authority, arguably within it, would constitute an official act subject to these immunity protections, which is, you can imagine, is a very vast swath of the president's actions while in office. I mean, a purely private act, might be the personal things you do, while you're going to bed or getting up or something. But most of the things that the president does during the day or, while he's on duty at night are, arguably within his official sphere of responsibilities.
Yeah. Justice Sotomayor wrote a fiery dissent, and she said that, and I'm quoting her here, a president could not be prosecuted as a result of this for organizing a military coup, for taking bribes, or even ordering the assassination of a political rival. The way you're reading the decision, is that a correct assessment?
I think it's fair. It's something that's going to have to be really hashed out in future cases. But in this area of core presidential duties, which involve command of the military, which involve appointing officials, where the court says that the president enjoys absolute immunity, conceivably that could cover if the president orders the military to murder a political rival, for example, or if the president takes a bribe for pardoning somebody, or takes a bribe from a corporation for removing a bureaucrat that the corporation doesn't like the way it's being regulated. Under sort of the broad language of the majority opinion, those kind of actions would seem to be shielded with absolute immunity, which I think is an extremely unwise position. And I do think it does go to sort of elevating the president above the law. And if there's one cardinal tenet in American constitutional law, is that no person is above the law, even the president of the United States, and should be accountable for any criminal acts that they commit. If a jury of Americans or the president's peers believe that the president was acting illegitimately and criminally in a particular situation, the founders would have believed that the president should be held accountable for those situations.
The liberal justices on the court say they fear for American democracy. The Biden camp said that Donald Trump was today effectively handed the keys to a dictatorship. Do you agree?
No, I don't agree with that. We have a lot of problems here in America with our democracy right now, and particularly the two contending sides in our two-party system. But I think that where this is going to be, where the threat to democracy really will be, is if we continue to have false challenges to electoral results. So I think the big question about the health of American democracy will be decided in November, when the voters go to the polls and cast their ballot for the presidential candidate. And again, if we see attempts to hold on to power, to subvert the legitimacy of those elections, when a number of courts have sort of reviewed the evidence and determined that there was no electoral fraud, at that point, I'll fear for American democracy. But, in terms of this particular ruling, we're just going to have to see how this very, very broadly worded opinion plays out in the future. I don't think most presidents of the United States, are inclined to commit criminal acts. That hasn't been our history. I mean, we've had some instances, but I think the real threat to American democracy is trying to subvert our democratic institutions.
That was Professor Barry McDonald from the Pepperdine Caruso School of Law. Thank you so much for sharing your insights.
Well, let's go through this with Nick Akerman, who's a lawyer and a former assistant Watergate Special Prosecutor. Welcome to DW. When he said that Congress may not criminalise the president's conduct in carrying out responsibilities of the executive branch, was the Chief Justice implying that Congress had passed laws to criminalise the former President Donald Trump?
No, not at all. I think what he is saying is that there are certain core functions of the president, such as making appointments, appointing judges, et cetera, that are the sole prerogative of the president, and those cannot be criminalized. Now, there are other sole prerogatives of the president, such as the pardon power, which Donald Trump did use and did criminalize by using it to obstruct justice in the Russian investigation. So there's a lot of problems with this opinion, and the decision that was made by the Supreme Court today.
Oh, because one of the biggest ones is that the inference from the justice's opinion that conspiring to overturn the presidential election can be considered to fall within a president's official duties.
That can hardly be true. That's what makes this whole opinion so bizarre, because the thrust of this indictment, if you read it from beginning to end, it all has to do with undermining the peaceful transfer of power from President Trump to President Biden. And there are a whole series of criminal acts that are alleged in that indictment. So that the idea that you can parse this out between official acts and private acts is completely inane. In fact, if you look at the Watergate matter with President Nixon, everything he did that he would have been indicted for if he hadn't been pardoned were what could be called official acts. The fact that he had one of his aides call the CIA and instruct them to tell the FBI to drop the investigation into the Watergate break-in could be described as an official act, much the same way that the justices described Donald Trump talking to the Attorney General. So none of this really makes a lot of sense, other than the fact that they're all trying to just delay this as much as they can so that Donald Trump doesn't have to face the music prior to the election.
So two things in that. Firstly, this sounds like you're saying that the highest court in the land is partisan and trying to side with the president, or with the former president. And of course, also from what you're saying, is one has to try and work out how this highest court of eminent legal minds has come to such an inane decision as you describe it.
Yeah, I mean, first of all, that's absolutely true. If you take what happened back in 1974 with the Supreme Court and the issue of Nixon's tape recordings, again, on that particular court, there were a number of justices who had been appointed by Richard Nixon, but they all unanimously decided, with one person recusing himself, that Nixon had to turn over those tapes. There was nothing partisan at all about it. This just has a different feel to it. It's had a different feel to it all along, ever since the overturning of the abortion decision, with the decision on the obstruction count that was used to indict a number of the January 6 rioters. This really does not make a lot of sense, other than to play into Donald Trump's strategy of delaying this whole matter until after the election.
But this, I'm sorry to dwell on this, but this is a big thing that you seem to be saying, that the Supreme Court now is, in effect, corrupt.
Yeah, I'm saying that because there's no way back in 1972, when we were investigating Richard Nixon and the Watergate matter, that anybody was saying, oh, there's presidential immunity. You have to be careful about what you do. We can't indict him. No one ever thought of that for a second. That was never an issue. It has never been an issue in our entire history until now. It was always considered that a president is not above the law. What Donald Trump has been indicted for are real criminal violations. They're alleged in indictment. He's got all the rights and responsibilities of anybody who's a criminal defendant. And now all of a sudden the Supreme Court has come up with this whole crazy new scheme about official acts and non-official acts, none of which make a lot of real sense when you really come down to the question of, did Donald Trump have the corrupt intent and the mens rea to commit the crimes that he's indicted for committing?
So now we have this decision. Presumably, there's no appealing. That's the law now.
Right. That's correct.
Wow.
And what it means is it's going back to the district court. And the district court now is charged with deciding which are official acts and which are not official acts. And then that's not the final word, because at that point, Donald Trump still has the ability to appeal that through the circuit court, through the Supreme Court, all of which is going to take even more time, probably up to a year. So there is no way that this case is going to a jury anytime soon.
And so how does this affect the case being brought by the special prosecutor, Jack Smith?
Well, it affects it. It's just going to be delayed more. I mean, it's very possible that Judge Chutkan, the district court judge, will go through each of those and make findings that these were not official acts. I don't know how you could ever say that trying to stop the peaceful transfer of power from one president to another is an official act. I mean, a president has no official authority in dealing with the election, with dealing with trying to stop the official count in Congress. That was up to the vice president. It's purely a ministerial chore. Certainly putting together false electors can't be an official act since it's a complete. I think what we're looking at is more delay.
All right. Thanks for taking us through that. Nick Akerman, lawyer and former assistant Watergate Special Prosecutor. Thank you so much.
Thank you.